I'm Justin Ziegler of Jay-Z Helps, a Florida injury law firm. Today I'm going to talk about Walt Disney World accident and injury claims in Florida. Disney does not have to automatically pay you just because you're hurt, okay? I'm going to get into that a lot later, but just for right now, understand they do not have to pay you just because you're hurt on their property or by them. If you're injured and you're treated by paramedics or taken via ambulance to a hospital, it's going to be Reedy Creek Emergency Services is going to be who takes you. The importance of that is you're going to need to later request your medical bills and records from Reedy Creek Emergency Services. And as soon as you get those medical records and bills, you're going to send them to Disney's claim adjuster. The address for Disney's Reedy Creek Emergency Services is here. I'm going to have it in the description to the video. It's also in the article. If 911 was called, you're also going to request that from Disney Reedy Creek Emergency Services, okay? And again, that contact information is here. When the accident happens, you're going to want to immediately report it to Disney if you're able to do so. Never, ever, ever, ever give a recorded statement to Disney. You're under zero obligation to give one. All it's going to do is potentially be used against you later on. In fact, you don't even have a duty to give a statement at all to Disney. When you're dealing with the Disney claim adjuster after your claim has been set up, just because they are friendly does not mean they're going to ultimately pay you. There's zero relationship between a nice adjuster and you ultimately receiving a settlement check at the end of your case. When it comes to giving a statement, if you choose to give one at all, you want to wait and be as slow as a turtle when giving a statement. Why? Most people, if not all people, after an accident happens and they're hurt, are going to be very emotional. Their heart's going to be racing. They're going to be angry, possibly. And you may say things that later on you regret. Most people talk a lot faster when they're nervous. You don't want to do that. You want to give it a lot of time. And if you ever give a statement to the Disney claims adjuster at all, you want it to be very, very, very long after your accident has happened. You're going to want to notify Disney in writing about your accident. And the purpose of that is so they have written notice of your claim, but you're also going to want to ask them to preserve video and pictures that they've taken at the accident scene. Disney's claim address is there. You're going to want to, the best practice is to email them, to fax them, and to mail it to them certified mail return receipt. You're going to want to send it to the place you are injured at and Disney claims, both of them, all those methods. If you choose to email Disney, and again, their claim address is there, you're going to want to do return receipt requested and delivery receipt. You're going to want to have evidence in writing that they received your notice of claim. If and when you send your letter of notice of claim to Disney, you're going to want in the subject line put the claim number. Will Disney immediately pay your medical bills or lost wages after the claim? Well, Disney is a massive business. They're worth about $172 billion. That's billion, not million. And most companies that are worth that much money and you're injured at that facility or establishment do not have what's called MedPay insurance. So you should not expect Disney to immediately pay your medical bills. Do not expect Disney to send you to a doctor, to their doctors. Some people say that, they ask, should I go? Will Disney send me to their doctors? Do not hold your breath waiting for Disney to send you to a doctor. If you need medical treatment, you need to get it on your own. Use your health insurance if you have any. If you do get a medical authorization that the Disney adjuster sends you, you're under zero obligation to sign it. And if you choose to sign it at all, I would recommend waiting a long time to sign it and also cross off the portion of any release that says that they're entitled to your mental health or psychological records or HIV-related records. When Disney if Disney chooses to send you an authorization to get your records, that does not mean that they're going to pay your claim. What that means is you're giving them permission for them to gather your records. They need a written authorization, otherwise your medical providers or the hospital will not release your medical records to them. Disney adjusters are going to look at past jury verdicts when deciding how much to offer you. And particularly, they look at the pain and suffering component of these past jury verdicts. Particularly, even further than that, they look at Orange and Osceola County, which is where you'll need to sue Disney if the case travels that far. This means that you should also know these jury verdicts. Now, the odds are you're going to have to subscribe to a service and pay a monthly fee or pay one-time fees and pay the service to request jury verdicts for you, and most people are not willing to do that. Attorneys have access, or attorneys should have access to these services. Again, you have to show that Disney was careless in order to recover money. If Disney was careful and did nothing wrong, you get zero. Disney, in Florida, I'm referring to, the claims adjusters are located on Disney property. What does this mean? That if you're injured at a theme park, a Disney hotel in Orlando, or Disney restaurant, the claims adjuster, if they want to, they can get to that accident scene within minutes after it happens, okay? To inspect it, to take video, to take photos of it. So it's a little bit different than, let's say you're injured at a Walmart, where the Walmart adjusters are not located at the accident scene. So this may give Disney an advantage in this instance. If you're injured at a restaurant on Disney property, Disney, there's a chance that they don't own it. If they don't own it, you need to write to the restaurant requesting their insurance information and notify them of the claim. I've never heard of Disney banning a visitor who was hurt on their property, so that's good news. You should preserve any evidence. You should do this in any claim on anyone's property. Just be sure to preserve any evidence, your shoes if you fell, or any photos that you took. Disney has the money, as I've discussed. They're worth billions of dollars. They have the money to pay any claim, which is favorable news if you're injured. If you purchase travel insurance through Disney, you would have done that through their website, maybe through a travel agent. That may cover you if you're hurt there. TravelX is the name of the insurer, and they may pay. You're going to need to submit a proof of claim within 90 days to TravelX. They may pay your medical bills. TravelX that insurance may also cover dismemberment or accidental death. The odds are in 99% of accidents, neither of those happen. That's good news. This is just a claim that shows you Disney will take a case to trial. They're not afraid. Parents won $2 million for their son who drowned at Disney. This is not my case, but the bottom line is people can have the possibility of recovering a lot of money. Obviously, this is a horrible situation. But understand that Disney is not afraid of your case, and they're not afraid of bad media attention. When looking to hire a lawyer, if you choose to go that route, I strongly recommend hiring a Florida lawyer, Florida injury lawyer. Why? It's going to reduce your stress. How? Because if you don't hire a Florida lawyer, number one, only Florida lawyers can sue Disney because they're licensed in Florida. If an out-of-state lawyer wanted to sue Disney, they would have to team up with the Florida lawyer and likely split the fee. If you sue Disney, they are going to hire an outside attorney, meaning he or she will not be an employee of Disney. This can act in your advantage because some other businesses, particularly car insurers, have their own attorneys on staff, and they're less worried about lawsuits because they've already paid their attorneys a salary. When you're dealing with Disney, they outsource their attorneys. Another reason why I don't suggest hiring an out-of-state Florida lawyer for your case is they may not know Florida's laws. Every state in the United States has different laws. Florida has different laws. The values of claims are different in Florida. I recommend hiring someone Florida lawyer. Another reason you want to immediately hire a Florida lawyer instead of an out-of-state lawyer is because if you hire an out-of-state lawyer and they begin working on the claim for a long time, and you choose to fire them and hire a Florida lawyer, the out-of-state lawyer is going to be entitled to a part of the attorney's fees, which means you're ultimately going to have to pay two attorneys, the Florida attorney and the out-of-state attorney, and that might make a Florida lawyer not willing to accept your claim. Now, Disney, as you know, owns a lot of theme parks, Magic Kingdom, Epcot, and many, many more. I hope you got a lot out of this video. Please like my video. Please subscribe to the channel. Please call us at 888-594-3577. That is 888-JZ-HELPS. Our office is in Miami. We serve the entire state of Florida. We would love to help you.